Labrīt, dāmas kungi, pulkstens 10, kā parasti mums tad bija jāsāk stingri saskaņā ar plānu. Mani sauc Edijs Poga, esmu Zvērnāts advokāts, biedrības Latvijas Tiesību institūts direktors. Biedrība Latvijas Tiesību institūts ir neatkarīga, nepolitiska, nevalstiska bezpeļņas apvienība, kur apvienojušās personas ar kopīgām interesēm par Latvijas tiesībām un to tālāku attīstību. Institūts vienmēr visur darbojas neatkarīgi un stāv ārpus politisko partiju vēstās politikas. Institūta misija ir veicināt Latvijas Republikas kā demokrātiskas taisnības un tiesību valsts tālāku atjaunošanu, nostiprināšanu un attīstību. Šī ir 10. vieslekcija mūsu 2014. gadā aizsāktās ārvalstu akadēmiķu vieslekciju programmas ietvaros. Un šī pirmā vieslekcija, kur notiek šeit Tiespilī, šobrīd Senāta, iepriekš Latvijas Tiesas palātas galvenajā zālē. Un par šo iespēju mēs esam bezgalīgi pateicīgi augstākajai tiesai un senātam. Šajā jubilejas reizē pie mums viesojās plaši pazīstamais Eiropas Savienības valsts atbalsta tiesību speciālists, Londonas ekonomikas skolas viesprofesors praksē, advokāts Londonas tiesas advokāta birojā Serle Court, karaļa padomnieks Conor Quigley KC ar vieslīdzību par Eiropas Savienības valsts atbalsta tiesībām un ārvalstu subsīdiju kontrolas tiesībām un to aktualitātēm. Kā zināms, profesors Quiglejs ir autors vienai no ietekmīgākajām monogrāfijām šajā jomā, ar nosaukumu European State Aid Law and Policy, kas ir iznākusi 4 izdevumos līdz šim. Vērts atzīmēt, ka 2003. gadā, kad iznāca pirmā Quigley kunga grāmata, tad ievadā autors norādīja, ka Eiropas Savienības valsts atbalsta tiesības uz to brīdi lielākā daļa cilvēku viņas uzskatīja par tādu kā Eiropas Savienības konkurences tiesību nabadzīgo brālēnu, pie kā cilvēki pieskarās tikai garām ejot, gan lekcijās, gan dažādos citos fórumos, lai gan valsts atbalsta potenciāls ir izkropļot konkurenci un nodarot kaitējumu patērētājiem tikpat lielā mērā kā karteļu un dominējošo stāvokļu ļaunprātīgu izmantošanu. Šīs grāmatas 4. izdevums, kas ir iznāca 2022. gadā, ir vismaz vairāk kā uz pusi biezāks, kas uzskatāmi nodemonstrē Eiropas Savienības valsts atbalsta tiesību attīstību straujo pēdējo 20 gadu laikā. Un šajā straujā attīstībā mēs varam būt gandarīti, ka ieguldījumu ir devušas arī Latvijas un citu Baltijas valstu tiesas un tiesību piemērotāji. Tad šīs vieslekcijas uzdevums ir iepazīstināt auditoriju ar šo pēdējo 20 gadu laikā notikušo attīstību un nedaudz pieskarties arī relatīvi jaunajiem ārvalstu subsīdiju kontrolas regulējumam. Vienlaicīgi pieskaroties arī šo divu tiesību režīmu pamatprincipiem un procesālai struktūrai. Kā parasti noslēgumā es institūta vārdā vēlos pateikties mūsu tradicionālajiem atbalstītājiem, augstākajai tiesību senātam, Latvijas Zvērnāta advokātu kolēģijai, konkurences padomei, žurnālam Juristu vārds, Eiropas Savienības tiesību asociācijai, Latvijas Universitātes juridiskajai fakultātei, kā arī advokātu birojiem Eleks Kļaviņš Sorenen, Everšķets Celons Bitāns un Kobaltu. Parastais mūsu standarts vieslekcija ilgs 2 stundas, iespējams lektoram būs nepieciešams neliels pārtraukums, un pēc šīs 2 stundu lekcijas būs neliela jautājuma atbilžu sesija, kur jūs varēsiet uzdot jautājumus, kas jūs varētu interesēt par valsts atbalsta tiesību aktualitātēm. Paldies par uzmanību un aicinu sagaidīt, kā parasts lektoru ar aplausiem. Paldies.
Well, good morning, ladies and gentlemen, and first of all, thank you very much for the invitation from the Institute. Thanks to the Supreme Court for the ability to speak in this room. Thank you for all your time and attention, and hopefully I'll retain that attention for the next couple of hours. Now, I was asked to talk on state aid and foreign subsidy control, and the way it was put to me was, could I give a comprehensive overview of EU state aid law and the new EU foreign subsidies regulation framed within the broader context of EU competition law? So I've taken a fairly traditional approach, I think, to dividing it up. And just so that you know what's coming along the way, these are the different points that I'll be making. So first of all, to deal with the issue of the context of EU competition law, one short section on that. Then the elements of state aid. Now, state aid is contained in Article 107.1 of the treaty. And so I explore there the different criteria which need to be applied. What I also do throughout, I think, and what I'm intending to do or hoping to do, is to highlight some of my own prejudices, you might call them, about certain developments in state aid law, which I either agree with or disagree with. And I'll try and make that interesting for you, so that it's not just an A to Z of state aid law, which you could get for yourselves just by reading any book, including my own. So hopefully this will make it more interesting. So we look at that. Then I briefly want to touch on taxation and state aid. Taxation and state aid has been a huge subject for the last, say, 10 years. When the Commission started its onslaught of investigations into mostly American or US multinationals, but not only them, in relation to the way that they use the international or multinational taxation system, dividing between subsidiaries, permanent establishments, etc. And the Commission invented a new method of state aid control for taxation, but we all told the Commission at the time that it was wrong. I spoke at several conferences way back in 2016 onwards, as did others, and every private practitioner told the Commission this is wrong. But the Commission stuck to its guns. The issues went through the courts challenging the Commission decisions, and ultimately, effectively, the Commission suffered a pretty much resounding loss. So we have to figure out in years to come whether that was a complete waste of the Commission's resources or whether there is still something for them to latch themselves onto. The one exception, which I'll deal very briefly with at the time, is the Apple case, which you may have been familiar with, which the Commission ultimately won, but for reasons which have also been heavily criticised by almost every private practitioner. But nevertheless, it's a win for the Commission. Then I look at compatible state aid, in other words, the state aid types which are permissible, and then looking at, first of all, control by the European Commission, how it regulates state aid. Secondly, what happens when we have what's called unlawful state aid, which is then subject to a recovery obligation. Then a session on a complementary role of national courts through the direct effect of Article 108.3, so that the Commission does one thing or has one function or several functions, and the national courts have other functions, sometimes the same, but which are limited, and it doesn't have, or they don't have the ability to rule on compatibility. Then I want to look at state aid and arbitration proceedings. Now, this has become an important development in the last few years. It's not entirely new. It's probably been going for about 10 years, maybe more, that some arbitration proceedings have raised state aid issues. And there have been two types of arbitration. One is what we call commercial arbitration, which the European Court is prepared to accept as long as there's a certain review available in the national court. The second is arbitration in international investment treaties, where the court has completely come down against the legality or the compatibility with European law of international investment arbitration proceedings, and has tried to stem the flow of those and by prohibiting them. But as we'll see, not every court everywhere in the world is prepared to accept what the European Court says. And then finally, I've been asked to look at the foreign subsidies regulation. I'll only deal with that relatively briefly. it's in the greater scheme of things, it's much less important, I imagine, for most of you here, although it may be of importance to some of you if you've had to deal with it. So, dealing briefly with the notion of of state aid and competition law in the internal market, and nothing magical about this really. The court has said in various judgments that state aid rules form a fundamental provision of EU competition and internal market law. Article 3.3 of the treaty, the Treaty on European Union, let me get that up, says that it establishes an internal market, but for some reason, I seem to remember this was during the negotiations of one of the treaties. It could have been Nice or Amsterdam or whichever. It was one of them anyway. For some reason, I think it was the French, took some objection to competition being given prominence in Article 3.3, so it was taken out, and instead it was put into a protocol, Protocol 27, to the TEU and the TFEU, which simply says that competition is part of the internal market rules. So there is a basis, therefore it's effectively the same thing as if they had included it in Article 3.3. Then what's the effect of the competition rules? So we can divide competition into two parts. One is agreements and restrictive practices under Article 101. The other is abuse of dominance under Article 102. In both of those provisions, they talk about the relevant activity being prohibited as incompatible with internal market law. So it's incompatible with the internal market, and it's also prohibited because or as it's incompatible. We go to Article 107.1 on state aid, it's slightly different. It simply says that state aid is incompatible with the internal market, subject to other provisions of the treaty. So it doesn't say anything about it being prohibited, but instead, Article 108.3, Article 108 deals with the control mechanisms by the European Commission. And it finishes with Article 108.3, which says that state aid must be notified to the Commission in advance and may not be put into effect until the Commission has reached the final decision. So the court says the effect of that is to prohibit member states from putting into effect state aid prior to any clearance by the Commission as being compatible. So there's no particular magic in the whole way it fits together, but that just gives a structure to how state aid fits in with competition and the internal market. So now I want to spend some time looking at the elements of state aid within Article 107. So Article 107 states that save as otherwise provided for in the treaty. Sorry, just get it in the hands here. Save as otherwise provided in the treaties, any aid granted by a member state or through state resources in any form whatsoever, which distorts or threatens to distort competition by favouring certain undertakings or the production of certain goods, shall, insofar as it affects trade between member states, be incompatible with the internal market. So I read into that a number of elements. The first is aid granted by a member state or through state resources in any form whatsoever. Second is that it must distort or threaten to distort competition. The third is by favouring certain undertakings or the production of certain goods. And the fourth is insofar as it affects trade between member states. Now, why the European Court couldn't have just taken those four elements as written in Article 107 and stuck to them as saying these are the criteria for the application of Article 107. But instead, it has adopted a slightly different terminology, and it has repeated this terminology in almost every case since. And that is, it talks about, it says there are 4 criteria, which I agree with. The first it says is there must be an intervention by the state or through state resources. So the word granted is gone. The word aid makes no appearance whatsoever. Then that is liable to affect trade between member states, that it confers a selective advantage on the recipient, and that it distorts or threatens to distort competition. So suddenly we have the phrase confers a selective advantage. So going back to the terms of Article 107, it says, any aid granted by a member state which distorts or threatens to distort competition by favouring certain undertakings. So there would seem to be a link between the by favouring certain undertakings and the distortion of competition. But in fact, they have said these are 4 separate criteria. They may interlink to some extent, but for some reason, you could have had one criterion distorting competition by favouring certain undertakings. But instead, they've said that these are 2 separate criteria. One is that it confers a selective advantage. The other is that it distorts competition. Now, I say that there's no mention of the word aid. And instead, in 2015, in a case called MOL, M-O-L, the Advocate General, Niels Paul at the time, he said that these 4 criteria weren't sufficient and that there was what he called a concomitant requirement, which was a concomitant detection of an economic advantage. So that is his bloated is the wrong word, but extended definition of the word aid. So aid is the granting of an economic advantage granted by a member state or through state resources. I'll come back to the distinction between economic selective and competitive advantages in a minute. But first of all, let's look at the notion of intervention. An intervention is where legislation is passed or where there is administrative action. Those are the most likely forms of intervention. The next one would be preparatory action. Now, what I mean by that is preparatory action to legislation or an administrative action, is that capable of being the grant of aid? And we'll look at that a little bit when we come to the definition of grant. Then I'll look later in relation to court action and arbitration. I can briefly deal with court action, which is that there was one case which effectively said, a Greek case, or that is a case involving Greece in front of the European Court called DEI, where the court held that the extension of an aid by the court on foot of an interim order was the grant of new aid. And so this gave rise to an argument or a debate as to whether courts could grant aid. And we'll see in a while that that's probably no longer the case. Then, equally, if a court can do it or can't do it, what about arbitration proceedings? Where arbitration proceedings result in the grant of compensation or money or whatever, payment from the state to a private party, is that capable of being categorized as the grant by the arbitration of state aid? So again, we'll look at that when I come back to arbitration later. Then we have state resources. If you remember, the treaty talks about aid granted by a member state or through state resources. And there had been this debate as to whether that meant that these were alternatives, so that you could provide aid through state resources or through the grant of state resources, or a member state could grant aid without necessarily invoking state resources. But whatever the original wording of the treaty, the court ultimately held that there are only two requirements. The first is that it must be imputable to the state, that is, that the action giving rise to the intervention must be due to the state activity. And that could be central government, regional government, local government. It could be public undertakings, as long as they are under, that is, publicly owned undertakings, as long as they are under the control of the state or direction of the state. And equally, even private undertakings where they somehow were using state resources. And again, where those resources were subject to state direction. The famous case of Stardust Marine many, many years ago set out certain criteria for establishing the circumstances in which a public undertaking would be regarded as being having its actions imputable to the state. The state resources thing also, one early case was Preußen Electra, again, very, very, very well-known case. In that case, German legislation required electricity distribution companies to purchase a proportion of their needs from renewable energy sources. This was a long time ago when renewable energy sources were rather expensive. And the question was that state aid? After all, clearly the state, by its intervention, by its legislation, was putting the renewable energy producers in a favorable position, thanks to the purchasing obligations being imposed on the private or public, for that matter, electricity distributors. But the court held that that was not a case of state resources, and it was not a case of state aid arising through that action. So then I mentioned that there's a distinction to be had between economic advantage, selective advantage, and possibly competitive advantages. And why do I think they are wrong or different? So it's not just an advantage. And unfortunately, the Commission does on several occasions just talks about an advantage. Sometimes it talks about a selective advantage, sometimes it talks about a selective financial advantage. But what it doesn't necessarily always do is draw the distinction, as the Advocate General did in the Mall case, doesn't draw a distinction between economic advantage on the one hand and selective advantage. So why do I say they're different? The economic advantage arises where the beneficiary's position is improved compared to its position without the measure. Let's take a tax exemption. If an undertaking is subject to corporation tax at 30%, and then there's an exemption for some of its activities or for research and development or whatever, and it could take advantage of that exemption, well, its economic position as a beneficiary of aid is improved compared to its position without the exemption. So you're comparing, in other words, by reference to the effect of the aid measure on the net financial position of the beneficiary. The selective advantage, on the other hand, going back to Article 107, is by favouring certain undertakings or the production of certain goods. So what the court says is that's favouring certain undertakings as compared to other undertakings not benefiting from the aid. So that's where it's selective. It's a selective advantage. It's an advantage to the beneficiary who gets the aid as compared to other undertakings who do not get the aid. But that is a separate advantage and quite a clear, in my view, quite a clear difference of categorization. Unfortunately, as I say, the court all too often simply repeats its standard 4 criteria without any reference to economic advantage. And that's despite the fact that the court has recognized that economic advantage is a criterion. So really there ought to be 5 criteria. And, and really the court should just bite the bullet. It doesn't like turning around and saying, well, actually, something we've said before is wrong, especially when they've repeated it ad nauseum. So it's unlikely the court will change this in due course, but in my view, it ought to. Then the other advantage is competitive advantage. And sometimes there have been a couple of cases where the General Court, anyway, has talked about a comparison with competitors. But technically speaking, it's not a competitive advantage. You need to show a distortion of competition, which is a slightly different thing, because the distortion of competition arises as a follow-on from the selective advantage and the economic advantage. Let's look then at grant of aid. A grant of aid is a grant of the economic advantage. Granted at the time the right to receive the aid is conferred on the beneficiary by the applicable national law. So that's the standard definition, that is granted at the time when the right to receive it is conferred, which may be earlier than the time when the actual payment is made. There is a difference, however, with multi-annual aid granted on an annual basis, where the beneficiary receives the aid individually every year. So let's assume there's a tax ruling which lasts for 5 years, and under that tax ruling there's a benefit. You could say it's the multi-annual scheme set out by the tax ruling which is the aid, and certainly the Commission in these tax cases over the last number of years has said that the tax ruling is the basis of the aid. But it also then has to look at the individual annual assessment, and that's when the aid apparently is awarded. So there seems to be a slight discrepancy in the logic there. A recent case which I include is particularly because it's a Romanian reference to the, or not so Romanian, it's a Latvian reference to the European Court. And that's the Tudor case, which was a judgment just quite recently. Let's see when it was. It was on the 1st of July of this year. So some of you may be familiar with it, some may not. That was a case where there was a system approved by the Commission for granting aid due to COVID. And it was limited to a certain period of time, as all of these decisions tend to be. An application was made to the national authorities here and National Tax Authority for a grant of the aid to Tudor, and it was refused on some ground, doesn't really matter which. But it was refused on the ground that it didn't fit within the national scheme. Tudor challenged that in the courts, lost the first instance, went to Court of Appeal, and that court made the reference before deciding whether aid had been granted or not. But it asked the question, if it were to find the refusal to grant the aid unlawful, so that the competent authority would then consider the aid, when was the moment when the aid was granted? Because if it was granted after the new judgment, the scheme would have come to an end under the Commission's rules. So the compatibility of the scheme would have come to an end. And so in a very ingenious, I think, and certainly a new application of the law, the European Court turned to the Charter of Fundamental Rights, and Article 47 of that, and based a law or a legal analysis that the grant had to be considered to be the time when the initial aid application was rejected, because it was at that time that the national authority unlawfully rejected the aid. And you couldn't penalise under the Charter. You couldn't, or you had to give full effect to the rights of the individual under European law. So it's an ingenious little case. So if anybody is in the audience who was connected to that case, well done. Can a national court grant aid? The DEI case in 2016 was a Greek case where there had been a contract lasting for a certain period of time which granted aid within Greece. Then that contract terminated and there was a contractual dispute between the parties. The court, hearing the dispute, decided to grant an interim injunction reinstating, so this was, I think, 3 months after the event, reinstating the aid. And the question was that a new aid, or was it part of the, or was it something that the court wasn't entitled to make? And the court seems to say that it was a new aid, and therefore the court was granting the aid. Now that decision was subsequently heavily criticised, at least by one Advocate General, and it's never been specifically cited as being followed in subsequent cases. But in another Latvian case is Dobeles HES from 2023, and that says categorically that national courts cannot grant state aid. It says what they can do, or what they do, is look at the legislation or the underlying act of granting the aid, and they can order that the aid be granted. But that is merely the consequence of their finding in favour or interpreting the law as it is. So that from a state aid perspective, the court is not granting the aid. It's the legislation which allows the aid to be granted. Now, I'll come back to Dobeles in a minute and come to this notion of whether aid is defined by its effects. Now, that comes from an early case called Italy and the Commission, way back in 1974. And in Italy and the Commission, there was a tax reduction for the textile sector in corporation tax in Italy. And the Commission decided that this was a state aid. And Italy challenged it on various grounds, but its primary ground was that it couldn't be state aid because it was fiscal. It was fiscal law. To which the court replied, Article 92 as it then was, does not distinguish between the measures of state aid or state interventions concerned by reference to their causes or aims, but defines them in relation to their effects. Consequently, the alleged fiscal nature or social aim of the measure cannot suffice to shield it from the application of Article 107. So it's saying state aid is defined by its effects. The question is, it didn't really say what that means. What are the effects of a measure? We've already seen that in Preußen Elektra, the effects of the measure in Preußen Elektra, the German energy case, was that renewable energy producers had a distinct benefit under the law, and yet that wasn't state aid. So you couldn't say that you just look to the effect of the measure, and yet that phrase, state aid is defined by its effects, has been repeated again and again and again by the European Court and by the Commission as the basis for many findings of state aid. So then, back to double S. Double S is I'm sure you're probably all familiar with double S. It was a reference from this court, from the Supreme Court of Latvia, asking a whole series of questions, 13 questions in total, which is very unusual, I have to say, for a reference. Usually it's 2 or 3 questions at most, but they asked a whole range of questions, most of which are technical, and I don't need to deal with them. But it was a brilliant judgment, brilliant case. But in terms of the effect, the court had this to say: the case law cited, according to which state aid under Article 107 is characterised by its effects and not by its objectives, does not mean that state aid is exhaustively defined by its effects to the exclusion of all other criteria. State aid is also defined by its nature, if only because it is granted through state resources, as Article 107 expressly provides. Consequently, the case law cited by the Commission does not have the scope which the Commission ascribes to it. In particular, no conclusion can be drawn from that case law concerning the possibility of a national court granting state aid. So it's hard to read into that exactly what the court is saying as regards the criterion of effect on aid. Is it saying, well, there is the criterion of effect on aid, but also you must look to the nature? And as I've already explained, the nature of that is it's attributable to the state and state resources. Or is it effectively saying, well, look, we always used to say it's defined by its effects, but actually that means nothing. And therefore you just look to, is it imputable to the state? Does it provide an economic advantage, et cetera, et cetera? I would prefer that that is the result of that case. So much for double S. Now, the next criterion is the effect on trade and distortion of competition. These are technically separate criteria. There are 2 of the 4 criteria in Article 107 and in the court's judgments. But normally they are examined together so that if there is an effect on trade, there's almost always a distortion of competition. And equally, if there's a distortion of competition, then there's almost always, at least at first blush, there's an effect on trade. Now that goes back to the case of Philip Morris. And this is another of my bugbears as to whether Philip Morris is actually authority for what the Commission and the Court have ever since said it's authority for. The facts in Philip Morris were that there was an application for a grant for an investment by Philip Morris in cigarette production. And the court analysed it that the completed investment would account for nearly 50% of cigarette production in the Netherlands, and that it expects to export over 80% of its production to other member states. So on that basis alone, you would say there's a clear effect on trade or potential effect on trade if the investment goes through. There's a clear distortion of competition because they are so dominant in the market. So the court then said, when state financial aid strengthens the position of an undertaking compared with other undertakings competing in inter-community trade, the latter must be regarded as affected by that aid. so that an organization or an undertaking organized for international trade, proved by the high percentage of its production which it intends to export, shows that there will be an effect on trade distortion. These circumstances, now this is the precise wording of the court's judgment, these circumstances justify the Commission's deciding that the proposed aid would be likely to affect trade between member states and would threaten or distort competition between undertakings. So the circumstances are 50% of the market, 80% of international trade. Clearly, that shows an effect on trade and distortion of competition. But the Commission, ever since, latched on one sentence, which preceded the court's judgment that these circumstances justify them. It says, as I've just mentioned, when state financial aid strengthens the position of an undertaking compared with other undertakings competing in intercommunity trade, the latter must be regarded as affected by that aid. Financial aid strengthens the position of an undertaking compared with other undertakings must result in aid. Now, the Commission took that to mean any aid, no matter how small, which is granted to one undertaking, necessarily is going to have an effect on competition and trade elsewhere in the internal market. And for some reason, the court has also taken up that mantra ever since. And that was 1980, was it? Something, 1980. So finally, over the last couple of years, or a number of years, the Commission had realised that it went too far. And it's tried to ameliorate the consequences in two different ways. First is by allowing for what it calls de minimis aid. Now, de minimis aid is effectively small amounts of aid. It's generally 200,000 euros over 3 years to a single undertaking, which is significant, but not that much. And then the second way is to say that local aid can be regarded as not having any cross-border effect. And it has made some decisions where even quite large amounts of aid, well, moderate amounts of aid have been granted to certain undertakings. It's been able to say, well, actually that aid was, or the activity was fairly localized. I think there was one to do with Slovenia, yachts or something in Slovenia, or marinas in Slovenia. So to that extent, the Commission has rolled back instead of always demanding that the activity be subject to state aid assessments. I should say two other, or at least one other criterion comes to mind, which I haven't mentioned yet, and that is that aid must be awarded to an undertaking. And an undertaking is an undertaking engaged in economic activity. So if it's providing a public service purely, it's generally not regarded as being state aid. You get this a lot in public transport, in public health, and other public areas, but I'll leave it at that, other than to say that it's where you have a hybrid system, public health in particular, where there's a hybrid system of private activity operating alongside public activity, then any state assistance to the private activity might, if it's significant, give rise to state aid concerns. So there are three broad methods of awarding state aid pretty obviously. One is direct grant of financial assistance. Here's 10 million euros, go and build a factory. The second is fiscal aid. That's the alleviation of a tax burden that would otherwise arise. That's generally been found to be a major part of the state aid systems in each member state. There was an interesting case in Ireland after it acceded to the European Economic Community many years ago, in the early 1970s. Ireland had a manufacturing profits tax of 10%, and the tax on services was 25%. And that had gone on for a number of years after joining the community. And then the Commission, I suppose, woke up one day and said that actually, from a point of view of corporation tax, profits from manufacturing should be treated in the same way as profits from services. So it suddenly decided overnight that the Irish tax system constituted state aid to the manufacturing sector. So the Irish, in their canny way, they changed the system so that all corporate profits, were subject to 12.5% corporation tax. And that's, to a large extent, still the same thing. So the alleviation of a tax burden has to be analysed in its circumstances. The third way of granting aid is through non-market state behaviour in commercial transactions. What I mean by that is that the state will be behaving nominally as a commercial actor, but actually is taking decisions which no rational commercial actor would take. So that can be the provision of aid. I jumped ahead myself on that thing. Let me just finish with, I'll come back to that in a minute, but let me just finish with fiscal aid. So, under EU law, member states retain sovereignty in setting tax legislation and rates. So if it sets, as I mentioned with the Irish case, as long as it doesn't provide state aid through the tax system, member states retain sovereignty to set the tax legislation and to set the rates, unless that is a tax which is governed by EU law, such as VAT or certain indirect energy taxes. So coming back to the non-market behaviour, there are generally three different categories where the state may be regarded as, in fact there are more than three, but the three major areas where it can be regarded as granting aid through non-market behaviour. First is through investments. If it provides capital into a company on terms where a private investor wouldn't agree to act, that's a non-market behaviour. So we used to have what was called the market economy investor principle, and as long as a state invested on the same way as a private investor in the same terms, same risk, then that wouldn't be regarded as state aid. There could be an exception to that where the provision of capital is available on the market, but not at the scale or size of the intervention by the state. So if the state steps in with a huge or huge investment because private banks have refused to step in on the same terms, that's a state aid. The second one is sale and purchase of goods and services. Here you have where the government purchases goods at an overprice or or services, or sells them at an underprice. So it's normally purchasing at sale usually is sale of land at a beneficial price to the purchaser, but purchase is purchasing goods. So how is the state to apply what we now call, in this broader context, the market economy operator principle, MEOP? Well, one way is to put out a public procurement system so that will test the market ability of the contract. It'll test and set, hopefully, the market price for for selling the goods or purchasing the goods. So that's regarded, as long as it's a sufficiently robust public procurement system. Normally, you're supposed to have at least 3 bidders for the tender to give a market flavour. And then that will generally be regarded as sufficient to preclude the award of state aid. If you don't have that, or if there hasn't been a public procurement mechanism for some reason or other, that's not necessarily the end of the matter. You can then move on to what the Commission calls benchmarking, and that is normally where you get economic evidence together which shows that it's not unreasonable for the state to have agreed the terms that it agreed to. So the trouble with benchmarking is that it comes usually after the event, and therefore it could be a couple of years later. The Commission is trying to analyse, or somebody else is trying to analyse, well, what ought to have been the case 2 or 3 years ago when this contract was awarded. So, and then the guarantees, where the state steps in and provides public guarantees to commercial behaviour, that must be on a normal commercial basis, and the Commission has set out guidelines as to what that means and the extent to which guarantees can be given. If you step over that mark, then there'll be a presumption of state aid. So moving on to taxation and state aid. As I said, taxation involves quite a lot of state aid these days, and I don't want to go through all the different cases or all the different circumstances or whatever, but one of the main cases in 2022 was the Fiat Chrysler Finance Europe case. That was one of the cases, one of the first cases where the court rejected the Commission's arm's length approach. The court set out various criteria, not all of which are listed here, but a few of which are. First is member states must refrain from adopting tax measures liable to constitute incompatible state aid. Second is general measures do not constitute state aid. Now, what's meant by that general measure? A general measure would be, let's say corporation tax is set at 30%, and then the Finance Act reduces that rate to 28%. So all companies pay 28% on their profits instead of 30%. That's a general measure. It's not state aid. What if general corporation tax is 30%, but there's a special tax on the banking sector at 50% to punish them for the financial crisis or get your own back on it? And they put that in at 20%, extra 20%. So it's 50% on banks. But it's corporation tax at 50%. Then the banks start to complain and said, look, we're not making so much money after all. We've had enough of the extra pressure. Can you reduce that to 40% or even to 30%? Well, so the government reduces the 50% to 40%. Is that a state aid? It's clearly a benefit to the banks, but it would be regarded, I think, as a general measure. What if you took it one step further and the banks pleaded, or if we take this into a different category, what about oil and gas producers in the North Sea? In the UK, petroleum revenue tax was 75%, whereas corporation tax was about 30%. Now, I don't know what the rate is any longer, but what if you're closing down North Sea oil and gas production, and the British government succumbs to pressure from the industry and says, okay, we'll abolish IPT. Is that an abolishment? Is that a state aid? What if it says, well, actually, we're only going to tax oil and gas at 20% from now on? It's still high. It's still petroleum profits tax. It's a separate tax from corporate tax. And we're just setting a rate at what we regard as an affordable rate for the industry. Is that a general measure? Is that state aid or what? So these problems do arise. A possibly more obvious one is where you have a tax exemption or tax deduction available for research and development expenditure. So let's say corporation tax 30%, but anybody involved in R&D can set the costs of the R&D off against their taxable profits, and therefore they get a tax deduction. Is that a state aid or is that a general measure? It's a general measure if you say, well, it's available to anybody, but it's possibly a state aid if you say it's only available to those who have the capacity to engage in research and development activities. So it depends which side of the telescope you're looking at. Now, then you've got selectivity, where taxation favors certain undertakings over other undertakings which are in a comparable factual and legal situation and which accordingly suffer different treatment. That phrase, originally, it wasn't the very first time the court used it, but it was pretty much the first time it hit the headlines. State aid, so that case was not Fiat Chrysler, it was the Spanish goodwill case in 2016 or so. State aid, as you say, so a selective advantage. Selective advantage favors certain undertakings, whereas here all of a sudden it was compared to others who suffer different treatment. So the suffering of the different treatment was not from the people who gained the state aid, but was from other people who didn't gain the state aid. So this was a new test, as it were, or at least it was a variation on the test. And the question should always be, well, is it correct? But anyway, once again, we're stuck with it. So that case was an interesting one where Spanish legislation allowed for a deduction on goodwill on the acquisition of non-Spanish companies. So if a Spanish company was acquiring a French company, it could deduct the goodwill, the cost of the goodwill it was buying, from its Spanish profits. Whereas it couldn't do that if it was buying a Spanish company. Now, had it been the other way around, that you could deduct the costs by buying a Spanish company, but you couldn't deduct them for buying a French company, that would have been regarded as an infringement of the free movement of capital provisions of the treaty. But as you know, I'm sure, the free movement rules don't prohibit reverse discrimination. In other words, where you discriminate against your own people in favor of foreigners, let's call them for want of a better word. But this is where the European Court stepped in and decided that this was a state aid, even though the Spanish company could decide whether it was going to invest in a Spanish company or invest in a French company. The Spanish company investing in a Spanish company suffered different treatment, even though it was, from the point of view of acquiring goodwill, it was in a comparable factual and legal situation. So then the general rule under taxation is to identify the three-step procedure. The first is to identify the relevant reference framework, which is the normal taxation, corporate tax, inheritance tax, property tax, whatever. So you identify the normal taxation, the relevant reference framework, then identify a derogation from the reference framework. And third, if there is a derogation, is that differentiation justified in that it flows from the nature or general structure of the system? I'm going to try and remember how this worked in, because I think he just mentioned it briefly in the advertisement that went with this, which was the UK CFC finance exemption case. So UK law has corporation tax. That's normally a reference system. It then added on the taxation of what they call CFCs, standing for controlled foreign companies. This is essentially where the UK taxman decides that a company has been set up to basically siphon off profits from the UK and from the UK tax system. So they introduced this CFC tax on CFCs. But then they provided for what they did call an exemption. And the exemption was in favor of certain types of loans or facilities. The logic behind that was that in the specific case, the profits arising were not forming some form of escape route from the UK. Instead, it was part of a normal financial system. The Commission said the reference framework is the CFC extension rules. And so there was an exemption to the CFC rule. And that was to be analysed. And they said on their analysis there was no reason to exempt these types of profits from the CFC tax. The UK ultimately successfully argued in front of the European Court that the tax, in fact, of the relevant reference framework was UK corporation tax, and that this exemption to the CFC charge was justified because it simply recognised that certain types of profits were not meant to be, diminishing the tax which would normally be due in the UK. So getting the reference framework is important. Then you have to identify the derogation from that reference framework, straightforward enough usually. But then you say, is that differentiation justified in that it flows from the nature or general structure of the system? I'm not going to go into that, but it just means that if you can show there is a justifiable differentiation, then that's permitted. So let's go on to this Commission attempt to fight multinational tax avoidance. It's generally thought that this arose from 2012 when Apple appeared in front of a US Senate or Congressional committee in relation to its American tax treatment of foreign profits which it was keeping abroad. And as a result, the European Commission stepped in as well and started analysing the very complex systems of multinational taxation. I am no multinational tax expert, so I'm not going to try to explain them. But it's, apart from fiat, you could notice there that targets of the Commission action were Starbucks, Amazon, McDonald's, Apple, and Nike, which then caused the certain, very many in the American House of Representatives and Senate to say that this was an attack on America. This could be the precursor to the present-day attack on digital markets, etc. But this is to some extent where it started. Fiat being an addition, maybe just to show that they weren't just anti-American. But what the Commission tried to argue was that under international taxation law, you had to take an arm's length approach to the division of profits between subsidiaries, permanent establishments, and branches. And it said, because there were OECD rules on this for the arm's length approach, but the Commission wanted to take it one step further and say, first of all, it didn't matter what the OECD rules said. As such, they could be good guidance, but they weren't binding on the Commission. Secondly, the Commission was entitled to say that if a member state didn't adopt an arm's length approach, which was consistent with the Commission's policy or Commission's aspirations, that was somehow a state aid. And it said that the arm's length approach was based on conditions of free competition. Now, I'd got that notion of free competition from an early case, 2006 case, Commission in Belgium in Forum 187, which had indeed dealt with international taxation and such things, where Belgium had got a system in place and then it derogated a bit from the OECD system. And the European Court was prepared to say that that derogation was a derogation from the conditions which would apply in free competition. So the Commission then jumped on that, or seized that as the source of a right which the Commission had to investigate whether all member states were taxing multinationals on the Commission's approach to arm's length. As I say, it eventually lost that approach, and instead it was decided that it was decided that in a case called Angie, that case Commission v. Luxembourg, or Luxembourg v. Commission, sorry, it was decided that taxation could only be levied by virtue of national tax law, and that the Commission had to accept what the member states said was national tax law, unless the Commission had a very good reason to believe that the national tax law was being disapplied in some form or other. So that got rid of the Commission's arm's length on the basis of a derogation from Article 107 argument. But the one case where the Commission ultimately won is the Apple case. Apple is very complicated. If you go through the original decision, the General Court, the Advocate General, and finally the European Court, it's about 500 pages of very detailed and intense and very contradictory analysis. So I have read it, but I'm not going to even try to summarize it. But the issue, or one of the central issues, I think I can summarize. So Apple Inc. is based in California. And Apple Inc. has a number of subsidiaries, two of which were Apple subsidiaries formed in Ireland according to Irish corporate law. But for Irish purposes, they were non-resident in Ireland, in that the board of directors supposedly met abroad. In fact, apparently, they just met in California. But they didn't meet in Ireland. Nevertheless, the companies, the subsidiaries, also had Irish branches, which did exist and operate within Ireland. And Apple Inc. transferred to the Irish companies intellectual property rights, which were extremely valuable and which made an awful lot of money. The question was, where was that profit taxable? And Ireland said, well, it's not taxable in Ireland because we only tax profits from the branch within Ireland. We don't tax non-resident profits or profits of a non-resident company. But the money wasn't repatriated as such to the United States, so it hadn't been taxed there either. So it was somehow sitting out in the Bahamas or somewhere. And the commission said, well, this doesn't make any sense. The IP rights must be somewhere, and they can't just be in some ethereal position in the middle of nowhere. So they said, in the absence of the subsidiaries showing where the IP rights were held, the presumption was that they must be held by the branch in Ireland. So all of a sudden, these relatively small branches in Ireland had massive billions and billions of profits in the Commission's view. And the Commission said that by not taxing those profits, that was state aid. And to everybody's surprise, in the Court of Justice, the Commission won the case. When I say to everybody's surprise, I mean some people, I think, have took the view that, well, Apple were baddies. They were just ignoring, they were playing the game of international tax and not paying up the amount of money. But when you looked at the Angie decision and the fact that the court, which was already mentioned in the Apple decision as well, that it's for national law to determine what's taxable in Ireland. The Commission was looking, this was for a tax ruling from 1994 and 1997. It was looking at OECD guidelines from 2010. And it said, well, we know we can't apply those guidelines directly to this case, but somehow by osmosis, almost, we could say that this was really what was at the back of the mind of the Irish tax authorities, even though the tax authorities said it's not on our mind at all. So the result was that Ireland gained all this right to taxation because it had to recover the state aid, and it's still wondering what to do with all that money. I should say that insofar as I've looked into this and read what other tax experts and people who understand the interaction between tax and state aid, that the ones I've read are vehemently opposed to the Court of Justice's decision. So, given that it's so complicated and unusual on its own facts, it's likely, in my submission, it's likely that the Apple case will simply be ignored going forward as setting a precedent, and that instead it'll be the other cases which set the precedent, and Apple will simply be regarded as a bit of an aberration. But of course, it can't be taken any further, so that's the end of it. Now, I'm running a slightly slower. I thought I might run out of things to say, but in fact, I so far haven't. I'm only going to be very brief then on compatible aid. Compatible aid is provided for in Article 107.2 and 3. It's automatically compatible if it satisfies Article 107.2. So aid to make good damage caused by natural disasters or exceptional occurrences are the main one there. The thing about it is, if it's automatically compatible, then the Commission still needs to check that it fits within the parameters of Article 107.2. So a member state can't just say, "Hey, we've awarded this aid; it's automatically compatible through Article 107.2. Therefore, that's the end of the matter." It still must get Commission's permission. Then the main category is Article 107.3, which gives the discretion to the Commission to allow for state aid, allow for compatibility of state aid. And the Commission has the sole assessment ability. I'm not going to go into the specific types of aids, but you can see them there. Regional aid in areas of abnormally low standard of living. In the early days, going back 30 or 40 years, that was reasonably large as an element of all state aid, 25% maybe. But that's been whittled away over the years. It doesn't apply at all now in Western Europe. Although there's a different type of development of economic activities or areas, it's a different type of regional aid under Article 107.3c, which does allow for, again, very limited regional aid within all member states, and also allows for aid for activities such as research and development and innovation, or energy and climate change. That sort of stuff has become big elements. Also, promoting an execution of an important project of European common interest. That's a favourite for the Commission. They love it when 4 or 5 member states get together and have a big project, because they regard that as being good for the European identity. So if they get their act together on that one, the Commission is prepared to allow the aid. Again, remedy a serious disturbance in the economy of a member state, and then culture and heritage conservation. All those were categories which were developed over the decades. Then we had, in 2008, we had the first of the crisis aids with the banking crisis. And the Commission introduced a new guidance, or a framework, which was remarkably more liberal in terms of the aid that would be allowed. No sooner had that more or less come to an end that there was the COVID crisis, so they brought in quite similar guidance. And then we have the Ukraine war, which again presents its own problems. So those allow for specific types of aid in specific circumstances. One of the criticisms, but one which there was no basis really in European law to tackle, was that it's okay, it's all well and good saying to countries, you can award aid in these circumstances. But the European Commission wasn't paying the aid. And therefore the argument was that only those governments which could afford the aid, such as in particular Germany, were able to take advantage of the frameworks. Now everybody did take some advantage of the frameworks, but the economic consequence of that, I think, is still being argued over. So then we have control by the European Commission. Again, I'll just be very brief. The control mechanism is set out in Article 108 of the treaty, and the procedural regulation number 2015-1989. Let me just check that's the right reference. It should be 1589, sorry. You was something wrong there. Anyway, that distinguishes between new aid and existing aid. New aid is, new aid, which a member state wants to put into effect. It must give advance notification to the Commission. The aid may not be put into effect pending the Commission decision. And then at the end of a preliminary investigation, the Commission may approve the aid, or it may open a formal investigation. If it opens the formal investigation, the standstill clause, that is, you can't put it into effect, remains in force. And then you moved on to different provisions of the procedure regulation and Article 108, paragraph 2. So this invites comments from member states and all interested parties. The final decision may approve aid, possibly with conditions, or prohibit the aid, and prohibited aid may not be put into effect. The approved aid may. Now, when the Commission invites comments from member states and all interested parties, it must do so openly, and it must give anybody who's an interested party sufficient notice that it's the aid which may affect it is being examined. I had a case just a few years ago called Mead Johnson, and in Mead Johnson there had been a complaint by Spain to the Commission regarding taxation in Gibraltar, taxation of international taxation from Gibraltar. 2013, the Commission opened an investigation, and then 2014, it opened a second investigation saying that this investigation was to identify what it called a tax ruling system. In other words, they were saying the Gibraltar tax authorities had a very lax tax ruling system. And then they identified 167 different tax rulings which had been made, and alleging that they were all part of this tax ruling system which was deficient. Anyway, in the final decision, they abandoned totally the notion of a tax ruling system as being a system of state aid, and instead simply went for 5 different companies, one of which was represented by me. The others didn't appeal. And we won in the general court on the ground that they hadn't been notified that their specific tax ruling was being examined in substance, as opposed to as part of a tax ruling system. So that was the end of that. The matter continues now because the Commission is trying to re-examine it on a different basis. So the Commission can organise or adopt a block exemption, which it has done. The main one is 651/2014. The block exemption, according to the Commission, covers something like in excess of 95% of all notified aid. So, in other words, all notified aid, all aid under the block exemption is deemed permissible. What the block exemption does is it lays down various general criteria, such as an incentive effect. In other words, aid can only be granted where it operates as an incentive to do something. In other words, it must be granted before the event and not afterwards. Afterwards, it's just money in your pocket. No individual assessment is required. Then we have guidelines and frameworks. Now I'll come on to the point. Guidelines and frameworks cover aid that is in the general subject matters of the block exemption, but doesn't quite satisfy all the conditions. But nevertheless, the Commission might be, on individual examination, might be prepared to accept them. And then finally, there's an individual assessment under Article 107.3 itself. That's rarely a case. It happens usually in the case of major projects which don't fall within a block exemption or don't fall within the guidelines. One of the early objections to the whole block exemption system was, and probably remains, that it allows the Commission, because this is a Commission regulation, it allows the Commission to determine the industrial policy of the entire European Union insofar as regards the provision of subsidies. Now, the Commission doesn't act on its own when it adopts block exemptions. It does consult with the member states, and there are meetings held. And I have no idea. Maybe some of you do if you work in this area. I have no idea how individual member states are satisfied with the block exemption system. Clearly, the block exemption allows some of the aid which member states want to be permitted, and it doesn't allow some others. So it does. I've always thought it does allow the Commission rather enlarged scope of competition analysis or competence. Then we have unlawful state aid and the recovery obligation. Aid granted infringement of Article 108.3 is regarded as unlawful, sometimes called unlawful, sometimes called illegal. Terminology doesn't really matter. So the Commission will then, if the Commission has investigated the matter, it will make a finding that the aid is unlawful. That's where the aid has already been put into effect. And there are procedures set out in the procedure regulation as to how that aid proceeds. Article 16 of the regulation requires that recovery be made of any unlawful state aid which has been granted. But it's the member states which must take all the steps necessary to recover the aid. Article 16 also provides that recovery is not required if contrary to a general principle of EU law. But the court has been very slow to accept what is meant by general principles of EU law that it might be contrary to. First of all, recovery is not regarded as disproportionate. It's regarded as the logical consequence of aid being unlawfully granted. So you grant it unlawfully, you recover it in its totality. Recovery is not a penalty. It's simply, again, the logical consequence. Now, there is what's called the protection of, or scope for the protection of legitimate expectations, but that is very limited. It's only where, bear in mind, this is where aid has been granted unlawfully by a member state. The protection of legitimate expectations is only where an EU institution has given reason to believe that the aid is either lawful or not aid or would be permitted. And that's generally not easy to get. There was one Spanish case where a commissioner had stood up in the European Parliament and declared that some aid scheme was not an aid scheme, and then subsequently the Commission decided it was an aid scheme. And so because people had acted on the basis of its statement in the Parliament, that provided some legitimate expectation. Recovery shall also include interest. If we go back to the Apple case, the interest was said to be, well, on an aid of 14 billion, which had run from 10-year period. It would have been, well, not sure when it began. But anyway, the interest was 6 billion of interest. The limitation period runs for 10 years under the regulation. So the Commission can only order recovery for a period of 10 years from when the date the aid was awarded. There's a Commission notice on recovery of unlawful aid which sets out all the rules. And failure by a member state, because as I said, it's the obligation is on the member state to take the necessary steps to recover the aid. Failure by the member state to do so leads to the member state being brought to the European Court on charges effectively. And if the Commission presents its case successfully, that will result in a lump sum, ultimately anyway, result in a lump sum penalty and a periodic penalty payment. And ultimately that does happen. What about the role of national courts then? So we've got Article 4.3 as a general provision that member states, including the national courts, must take all appropriate measures to ensure their fulfillment of their obligations under EU law. The procedural regulation does not apply to national courts. Instead, the Commission has produced a notice on enforcement of state aid rules by national courts and identifies, as does the case law of the CJEU, the powers of national courts. First of all, a national court has the power to interpret Article 107.1 and the existence of aid. In other words, it can determine whether a given measure does or does not constitute state aid. Of course, it can get it wrong. It might say it doesn't constitute state aid when in fact it does, but there we are. Its other main function for the National Court is to determine whether notification under Article 108.3 has been effected. So it has these combined functions under Article 107.1, determining the existence of aid, and then Article 108.3, determining that the aid hasn't been notified. It can make a reference, of course, to the European Court under Article 267, and there is a cooperation procedure set out with the European Commission, whereby the court or national authorities can engage with the European Commission and ask them for their guidance. But there's no power for a national court to consider compatibility of aid. That is solely for the Commission. So an infringement of Article 108.3 is directly effective. Now bear in mind, the infringement of Article 108.3 is an infringement of European law by the member state. It's not an infringement of any law by, at least not European law, by the recipient. So the recipient is put in this position whereby it has received state aid, which ultimately may turn out to be unlawful. And if it does, then the national court is, by virtue of its directly effective obligation under Article 103, is required to recover the aid. There's an interesting case, Este Pagar from 2019, which is a reference from an Estonian Supreme Court, which covers some interesting points additional to the pre-existing case law. First of all, it says that any national authority, so not just the national court, but any national authority, where it discovers that it has granted state aid which shouldn't have been granted, then it must recover that aid on its own initiative. The recovery must include interest, and crucially, there is no right to claim a legitimate expectation against the member state on the basis of the member state's behaviour. As I said earlier, that legitimate expectation is only permissible as against the European institutions. Now, I want to spend a few minutes on state aid and arbitration proceedings. This divides into two different types. There's arbitration pursuant to international investment treaties, which I'll deal with first. And then there's arbitration pursuant to commercial arbitration agreements. And entirely different rules apply depending on which is the source of the arbitration proceedings. Where the arbitration is pursuant to international investment treaties, these are either bilateral or multilateral treaties agreed by member states or some or all member states and other countries as well. The one that has given rise to most difficulty recently, I think, is the Energy Charter Treaty, which is a multinational treaty which the European Commission frowns upon, and in fact has, I think, commenced already withdrawal, as have many member states, withdrawal from the Energy Charter Treaty. But the Energy Charter Treaty provides for international arbitration where a provision of the treaty has been infringed. The most common alleged infringement is the requirement of fair and equitable treatment. The European Commission takes the view that, and as does the European Court now from the Acme and Constroy cases, takes the view that an investor's rights are sufficiently protected by EU law, rights of investment, etc. And therefore, they should not be entitled to additional rights under the Energy Charter treaties, fair and equitable treatment provisions. This means that there is a clash between the treaty on the one hand and EU law on the other. In Constroy, the European Court focused on 2 or 3 different provisions to deny the right of people to sue member states within the European Union. The first was that there was no right to refer questions of European law to the Court of Justice. Secondly, there was an infringement of Article 344 of the treaty, whereby member states may not refer disputes to other forms of settlement. The idea being that under the treaty, different member states had agreed to refer to, or to defer to other forms of settlement, and their nationals were entitled to take advantage of that. So you had a Swedish national suing Romania, for instance. And there's no right of appeal to national courts. So ultimately what the European Court has decided is that all of those international arbitration proceedings are simply invalid. They have no jurisdiction. Member states' courts, when called upon to enforce any award, must not do so. However, that's only half the story. So you've got lots of other countries in the world. And so what beneficiaries or claimants or applicants have been doing is commencing their arbitration proceedings outside of the European Union, then going to a court of another country and getting that court to declare the arbitration award binding, and basically saying, we don't particularly care what European law has to say about this. So I've been involved in, again, a number of these cases, and just last week there was a set of 4 cases, the main one being called Blasket Renewables in Spain, where Blasket had got an award and sought to enforce it in Australia. And the Australian High Court said that they would award it on the basis that there was an infringement of the Energy Charter Treaty that had been established by the International Arbitration, and that European law could not be used to prevent the application in Australia of those rules. Now, the European Commission begs to take a different view, and what it has done is, in parallel to that type of case, it says, it issues a warning to Spain that if Spain is to pay up on that arbitration award or on the judicial award, then that will be a state aid in any event. So this system of disputes is not yet clear. Who's right, who's wrong, who's capable of enforcing what law. So it will run and run. Then we have commercial arbitration proceedings. Here it's much easier. And what we have is that many years ago, in 1981, I think, there was the first case where the notion of arbitration was raised in the European Court. And the court gave the impression that it would not resist arbitration proceedings. Now, the trouble was with arbitration proceedings, they, like in the international proceedings or investment proceedings, those proceedings have no right to refer questions to the European Court. So, since one of the issues of the European Court of Justice is that there must be a right to ensure that European law is fully and effectively applied throughout the European Union for all parties, then the argument was that arbitration might not be effective on a commercial basis. However, in the EcoSwiss case, the court summed up its approach. And it said, first of all, this was not arbitration between two different member states. This was an arbitration agreed by private parties. Secondly, the review must be allowed under national law, but that review could be limited in scope. Thirdly, EcoSwiss decided that this approach applied equally to competition law disputes, although the dispute in question was EcoSwiss and Benetton International, so it was a private party dispute. I forget about the insertion review. Then, so the review must be sufficient, but it may be limited. But there must be a right of review available in national courts. Subsequent cases, Mastanzo Claro dealt with consumer protection. International Skating Union and Serle dealt with free movement. Serle was just from a couple of weeks ago. I have it here somewhere. Yes, just a couple of weeks ago, 1st of August 2025. And what Serle did was it simply repeated the law, so that it's now, I think, beyond doubt that, and Serle specifically said that it applies to arbitration involving the four freedoms: free movement of goods, services, capital, and people, and competition law. But in competition law, it's specified on the basis of EcoSwiss, specified Articles 101 and 102. So, arguably, it hasn't yet come to a decision where state aid arises in an arbitration proceedings. Now, how does state aid arise in commercial arbitration proceedings? Well, again, the cases I've been involved in have nearly always involved, other than the Spanish renewables case, which is the Blasket case, have involved a contract, a major commercial contract, where the government or a public authority has entered into a contract with somebody, usually involving tens of millions of pounds, didn't have a proper procurement procedure, and or the party to the contract simply didn't perform properly. So the government then wants to rescind the contract. And in the cases I've been involved in, the argument was, so you've got the service provider sues the government. The government says the contract, because it's usually following a change of government, which takes a different view from the previous government. And so in the change of government, the new government says, well, we would have never have entered into that contract in the first place. It doesn't satisfy the market investor principle. So we're going to resist paying any further payments under the contract. Secondly, we're going to seek recovery of any payments we've already made under the contract, because that has constituted state aid. And thirdly, that's enough to keep us going. So usually in that circumstance, the applicant says, or claimant says, but any illegality involved in state aid is your fault. You can't claim your own illegality in a national claim. To which the answer is, or has been put, that state aid law and the prohibition on it is definitive. It's not subject to compliance with national law, and no national rules can limit the full effect of the state aid provisions. Now, there's support for that in an article written 10 years ago by what was then a semi-senior member of the European Commission's legal department on state aid, and subsequently became a senior member. And he said that it was quite clear that commercial arbitration proceedings could include state aid proceedings, in particular where there was a contract at stake. Leaves open questions whether parties could enter into arbitration proceedings, for instance, in relation to unpaid tax or something like that. We'll see. So that's all I want to say about arbitration proceedings, but just to show that it is part of the process. So now I move on to the regulation. And I only want to deal with this briefly because I suspect, first of all, most of you are not involved in the foreign subsidies regulation. And count your blessings. So, what is the foreign subsidies regulation? It was adopted in 2022 on the basis that Europe had its state aid control, which governed states' subsidies payable to companies who were operating in the internal market. But there was no specific provision governing the subsidies paid by third countries. The big bogeyman was supposed to be China. Aid paid by third countries to undertakings which were then doing business in the European Union. And so they decided they needed to introduce a new system. The difference, I mean, there are some major differences between the state aid provisions and the foreign subsidies regulation. Not least that there's probably a notion that the foreign subsidies regime is not as invasive as the state aid regime. But nevertheless, it's intended to contribute to the proper functioning of the internal market and lays down a harmonized framework, i.e. harmonized meaning member states can't have different rules, to address distortions caused by foreign subsidies, and ensuring, therefore, a level playing field within the internal market. So, we talk about foreign subsidies. I've already talked about state aid, and state aid is, in a sense, reflected in foreign subsidies. And Article 3 of the regulation sets out the criteria. But there's a distinction, and a very important distinction, made between foreign subsidies and foreign contributions. So the foreign contribution is, as it were, the gross amount of money that might be paid to an undertaking. The foreign subsidy is the amount which causes damage. It's just, I don't know. So what it says is a foreign subsidy shall be deemed to exist where a third country provides directly or indirectly a foreign contribution which confers a benefit on an undertaking in an economic activity. So it's not just a foreign contribution, but that foreign contribution must confer a benefit. Now, when we look at the types of foreign contribution, they include the transfer of funds or liabilities, such as capital injections, the foregoing of revenue that is otherwise due, or the provision of goods or services. Now, the reason why this is important as a financial contribution, of course, you can say, well, it's the amount of the contribution which provides a benefit which is really an issue. But there are pre-notification requirements in relation to mergers and public procurement. And those apply, those thresholds are set in terms of financial contributions. So for instance, where one of the criteria is the provision of goods or services or the transfer of funds, it's the gross value of goods or services which are transferred, not, as in state aid law, the difference between the payment and the value. So there are differences there. And Article 4 talks about distortions in the internal market. A foreign subsidy is liable to improve the competitive position of an undertaking, actually or potentially affects competition. So we notice there's a slight change there from a terminology in Article 107, but nevertheless, it probably is intended to get across the same meaning. I don't think people regard them as being terribly different. And then there are indicators of a foreign subsidy liable to improve competition, which are by reference to the amount of the subsidy, the nature of the subsidy, the situation of the undertaking receiving the subsidy, the level and evolution of the economic activity, purpose and conditions of tax. Anything under 4 million is unlikely to distort competition, distort the internal market. That's quite high, and it's much higher than in state aid terms. And then the de minimis rule is also a bit higher. No, maybe not. So de minimis pretty much the same. And again, foreign subsidies are allowed for certain types of, for instance, natural disasters or exceptional occurrences. That refers back to, or cross-refers to Article 107(2). Then it lists categories which are most likely to distort competition. And the categories listed there are things like rescue and restructuring aid, where there's no plan in place to restructure the industry. That's very similar to European law or state aid law. Other provisions are found either in state aid law or in WTO subsidies law, so there's no real differentiation there. Then there's a balancing test. So whereas under Article 107 or 108, the Commission assesses the compatibility of the aid, here you've got a balance between the negative effects of distortion against positive effects. So the question would be, well, what are those positive effects? And there's slight different terminology again in the... So the Commission may, on the basis of information received, balance the negative effects of a foreign subsidy in terms of distortion in the internal market against the positive effects on the development of the relevant subsidised economic activity, while considering other positive effects of the foreign subsidy, such as broader positive effects in relation to the relevant policy objectives, in particular those of the Union. So I'm sure that could be written in fewer words, so the relevant policy objectives, what it doesn't do, and what the Commission has, I think, decided not to do, is to say all aid which would be permissible under Article 107(3) is automatically going to be regarded as permissible under the balancing test here. And yet, it's probably much the same thing. At the same time, some policy objectives in other countries throughout the world may be more broadly based for one reason or another than policy objective rules in the internal market. And for the European Commission to start imposing EU policy law in relation to other countries is maybe not a step that even the Commission wants to take. Where it finds that there are problems, it can impose redressive measures, or it can accept commitments offered by the undertaking. There is provision in Article 108.2 for conditional acceptance of state aid, or acceptance of state aid subject to conditions. So this is not necessarily new, but it goes much further and reflects, I think, the fact that subsidies in practice are more focused on merger activity, and therefore the remedies which may be proposed are similar to remedies under the merger control system. Won't say any more about that. Then there are three different types of control. There's the ex officio control, or ex officio review by the Commission. The Commission acts on its own initiative or pursuant to information from any source. I'm coming to my 2 hours up, so I'm going to leave the rest of that. But that's ex officio. Then there's concentration or merger control, where a merger has a turnover of more than 500 million and a contribution of more than, financial contribution, not a subsidy, of more than 50 million. There's a prior notification. Similarly with public procurement. So we're now up to 2 years of investigations. DG Comp found the work such that it had to appoint 40 different officials to look after notifications on, and it only deals with mergers. There's hardly been any ex officio investigations. There are only 2 that we're aware of. Merger investigations, it was originally anticipated that there would be about 30 notifications every year. There were in fact 179 notifications in the 2 years to July 2025, and yet only 2 of those led to in-depth investigations. Procurement, on the other hand, is looked at by DG Grow, which is not part of DG Comp, and they have had 2,000 filings. And of those 2,000 filings, there were only 3 investigations into proposed transactions, all of which were ultimately withdrawn. Finally, then there are forthcoming guidelines. If you really wanted to make a comment on that, you've just missed the opportunity since the deadline expired yesterday. So that, ladies and gentlemen, is my speech. Thank you very much for your attention.